Okay, then, Vande Sensei, the floor is yours.
Good evening, Ascola Asia. Professor Wakui, thanks for having me and for organizing this. When to punish and when to persuade? When do you use sticks and when do you use carrots? And if you use carrots, how do you do that? What's the best way to do so? Those are questions which all competition enforcers face, and Japan's experience is particularly instructive on those points. Because Japan has developed a wide range of consensual enforcement tools, or I call it consensual tools, and I'll explain in a minute what I mean with that. And in times when the effectiveness of competition law enforcement is questioned in jurisdictions such as the EU and the US, jurisdictions that have traditionally relied more on deterrence, fines, litigation, and less on consensual methods of enforcement, that's an important topic. And so what I propose today is that I first make the case that enforcement of competition law in Japan is indeed particularly consensual, that it has a strong emphasis on carrots. That will be the first part. And then in the second part, I want to make some suggestions as to why that is so. And third, I want to talk about how effective that approach has been. And specifically, I want to assess whether it could be considered as a form of responsive regulation. That's a highly influential approach to enforcement that tells enforcers to speak softly but carry a big stick. And what that means is that enforcers should use soft measures based on cooperation as much as possible, use persuasion because that's more effective. But if that doesn't work, they shouldn't hesitate to escalate and become more aggressive and use a big stick. All right, so is enforcement of competition law in Japan, enforcement by the Japan Fair Trade Commission, the JFTC, is it indeed consensual? Well, of course, all competition authorities use a mix of persuasion and punishment, deterrence. And that's true for the JFTC. It's also true for the EU Commission, for the DOJ, the FTC. Of course, that's true. But I think there's nonetheless a contrast between enforcement by the JFTC in Japan on the one hand and enforcement in jurisdictions such as the EU and US on the other hand. The JFTC comparatively relies much more on consensual ways of enforcing competition law. And with consensual ways of enforcing, I mean things ranging from advocacy all the way to commitment. So you have advocacy, consultations, informal warnings, informal cautions, voluntary measures, commitments. All of that is based on the cooperation of the companies. And that stands opposed to other types of enforcement, fines, cease and desist orders, imprisonment, criminal sanctions, which are of course not consensual, but more coercive. And yeah, the contrast between Japan and on the one hand and the EU and the US on the other hand is particularly obvious in cases involving digital platforms. In the EU, those cases have led to very high fines, well known to the 3 Google cases, but there's also battles ongoing with Apple, with Facebook. Likewise, in the US, the DOJ has sued Google, the FTC is suing Facebook, is seeking divestitures. So there's a lot of litigation, a lot of non-consensual enforcement going on. Now, if you contrast that with Japan, the contrast is quite stark. This is a timeline of the cases which the JFTC or the investigations which the JFTC has closed against big tech in Japan. You see there's quite a few cases. The JFTC has been quite active in digital markets, and there have been a lot of cases. I have a complete list here in this table, but it's more of a test for people's eyesight, I think. So it's just, I will share the slides later, so you can if you need this table, you can find it in the slides. But the point of this is not to go into all these detailed cases, but the point is that all of these cases.
Ascola バンデルサイモンさんか。
Sorry for the interruption. Vande Walle sensei, I'm sorry that you have to unmute yourself again.
Oh, okay. Was I muted until now? No.
Not for 5 seconds.
Okay, no worries. Okay.
My mistake. I'm sorry.
No problem. So yeah, so the point of these slides is not to go into the detailed cases, but the point I wanted to make is that all of these cases in digital markets have been resolved by the JFTC through commitments or through voluntary measures. So the companies have offered to stop their conduct or have committed to stop their conduct, and in return, the JFTC has closed the investigation without finding a violation. So I guess there's a stark contrast, and it's very clear in cases involving digital platforms, but I think it is part of a broader pattern. And also the consensual measures or the consensual enforcement methods which the JFTC uses, it's not just commitments and voluntary measures. No, the JFTC uses a wide variety of tools, and it has developed a very rich set of mechanisms to steer the conduct of market participants. Again, competition authorities in the EU and US also use these to some extent, but I submit that the JFTC does so to a much greater extent. And some of these numbers here, they're truly impressive. The JFTC frequently uses market surveys, which then lead to reports and sometimes discussions with the industry. And there have literally been dozens of these fact-finding surveys, these market surveys in the past few years. The last ones were on fintech and the sale of smartphones, but just in the past couple of years, there were surveys on app stores, on subcontracting for software, on pricing in IPOs, on cloud services, on public procurement for IT systems, on credit cards, digital advertising, point systems, cashless payments, online restaurant review sites, B2B transactions on digital platforms, online news platforms, convenience stores, logistics, and more. So it's really a very frequently used tool. And these reports don't just describe the state of competition in the market, they typically highlight practices that may violate competition law. Of course, the reports don't conclude and say this is a violation, but they highlight problematic practices. And the JFTC then uses these reports as a tool of persuasion to market participants. You know, this type of conduct, watch out, it could violate the Anti-Monopoly Act. And in some cases, the report is then used as a trigger to enter into discussions with a sector and to increase awareness and improve compliance with competition law. But there's other tools, consultations. Again, all authorities do that, I'm sure. I've been involved in many consultations myself, but look at these numbers. The JFTC in 2021 had 1,885 consultation cases. So 1,885 cases where the companies came to the JFTC and consulted on how to comply in a specific case with the anti-monopoly law. So these are very high numbers in my view. a little bit more intrusive, but still very consensual, or still very gentle, are these measures, cautions and warnings, which the JFTC can issue to companies. And here again, you have a pretty high number. And then finally, also in merger control, I don't really talk about merger control today, but in merger control as well, there's this preference for a consensual solution, meaning remedies rather than prohibitions. Since 1947, there hasn't been a single prohibition decision, so parties either offer remedies or they voluntarily abandon their deal in some cases. One important thing that I forgot to mention is that what I describe here, this emphasis on consensual enforcement, it's true for non-cartel cases. So my talk today is about non-cartel cases. Although consensual enforcement is very prevalent, it's not the case that the JFTC never takes formal measures and never imposes sanctions. It does so from time to time, but it doesn't do so in great numbers. In the past 5 years, the formal decisions, so the cease and desist orders, have almost all been issued in relation to cartels, actually, cartels and bid rigging. And in that area, the cartels and bid rigging, the JFTC also, together with the prosecutor, occasionally seeks criminal prosecution. So the situation in cartels is a bit different. When the JFTC does go for a confrontational approach, it almost always wins. In the criminal cases, so that's in cartels, it hasn't lost a criminal case in 38 years. But also for the cease and desist orders, the surcharges orders, which are the orders by which the JFTC imposes fines, surcharges and fines. I use the two words interchangeably. So fines as well, they are of course sometimes appealed, but the JFTC almost always survives the challenge, and the courts ultimately approve the JFTC decision. Now, why this consensual enforcement of competition law by the JFTC? Well, it's difficult to prove, of course, what the true reason is, but in my view, there are two explanations which appear particularly persuasive. But first, let me say what I think is not the reason. I don't think it's because of a lack of legal powers that the JFTC opts for a consensual approach. No, in fact, the JFTC could issue cease and desist orders, it could impose fines, and it could even seek criminal sanctions. So the Anti-Monopoly Act certainly gives the JFTC sufficient powers to engage in more antagonistic, more aggressive enforcement. Is it a lack of resources? Well, I'm sure the JFTC doesn't have resources to spare, but it could shift some of the resources it spends on consensual enforcement to more adversarial enforcement. The market surveys I mentioned, they're quite extensive. Many of them involve hundreds and some of them even thousands of respondents. And so it could, if the JFTC wanted, it could shift some resources from the consensual enforcement to the more adversarial enforcement. So what is the reason then? Well, the two reasons that are most persuasive to me are the following two. The first one is that the JFTC seems to hold itself to a very high standard. It's very risk averse. Of course, no competition authority wants to lose in court, but for the JFTC, this seems to be even more important. And that's also something, interestingly, which you see in the general Japanese criminal justice system. Prosecutors in Japan only prosecute when they're almost 100% certain that they will win. And then as a result, the conviction rate in criminal cases in Japan is very high. And the standard explanation for that very cautious attitude among prosecutors is that it is important for the legitimacy of the prosecutor or the not to lose a case in court. And I think there's an interesting parallel. I suppose the JFTC or the staff at the JFTC is afraid of losing before court and would be concerned that a court loss would undermine the legitimacy and its authority if it were to lose in court. And it's true, if so few cases are lost, and that is the case, the JFTC, like the general prosecutors, rarely lose. And so if the JFTC does lose, it's a big deal. It attracts a great deal of negative attention, which of course in turn makes staff even more keen to avoid a loss. So it's a bit of a vicious circle. And I think that's one reason. Another reason has to do with the political and institutional setting in which the JFTC operates. The JFTC is, of course, independent, but it's not the only government body out there. For a long time, the political setting in which it operated was hostile to aggressive or to vigorous competition law enforcement. And attitudes have changed gradually since the 1990s, but there's still resistance to the type of hard-nosed competition law enforcement that has become common in Europe and the US. And I think the most spectacular illustration of this was provided recently by the backlash which the JFTC faced when it was a little bit tough on a merger between two regional banks. The JFTC had concluded that the merger, this was a merger between two banks based in Kyushu, and that this merger, the JFTC said, would harm customers in certain regional markets. And initially, the parties refused to submit remedies, and the investigation dragged on. Ultimately, a compromise was reached, and in August 2018, the JFTC cleared the merger with remedies. So you would think, oh, that's still very consensual enforcement. Indeed, it is, but that's not how the other government officials saw things. And in fact, the JFTC's stance and the fact that it was a little bit tough on really asking for remedies led to a strong backlash. Japan's financial regulator, the Financial Services Agency, openly criticized the JFTC. And in 2020, the Japanese Diet enacted a law exempting mergers between regional banks from the JFTC scrutiny. I think it's valid for 10 years. So it's kind of a punishment for the JFTC. If you ask me, I mean, it must be quite traumatic for an agency to suddenly your jurisdiction is taken away over certain mergers. And so I think that illustrates that aggressive enforcement is not without risks, to put it mildly, for the JFTC. Okay, now, how effective has the JFTC's approach been? Well, before we talk about that, I want to introduce the concept of responsive regulation, because at first sight, the Japanese style of enforcement seems to follow the precepts of responsive regulation theory. And if so, it's possibly very effective. At least that's what the responsive regulation theory would predict. So what is responsive regulation? Well, it's an approach to enforcement. It has garnered a lot of praise. The OECD recommends it. There's a whole network of scholars advocating it. And you can think of it as an attempt to transcend the traditional opposition between, on the one hand, the stick approach and the carrot approach on the other. So the carrot approach that says, well, you need to use persuasion, not deterrence, because deterrence will get you defiance. If you If you persuade, by contrast, you leave the sense of responsibility of people intact. By contrast, if you punish, then you antagonize and you get less compliance. So that's the carrot approach. But then the stick approach says, well, hey, companies are rational actors, and if you don't hurt them where in their wallet, if you don't impose fines or make it unprofitable in other ways to engage in a competition violation, well, it will just be rational for them to infringe competition law, and they will do so. So responsive regulation recognizes that there's truth in both of these approaches. People have various motivations, and some companies behave rationally and only think of a calculus between fines and profit, and other companies are socially responsible and want to comply with the law because it is the law. And maybe within one single company, you may have different views on or different motivations on complying. So any sensible enforcement strategy has to combine carrots and sticks. And the way to do that is through what responsive regulation theorists call an enforcement pyramid. And at the bottom of the pyramid, you have the dialogue-based, the cooperative measures, the carrots, if you like. And as you go up the pyramid, the measures become more severe. And the idea is that authorities or regulators should always try the bottom layers first and move up gradually if that doesn't work. If they don't get compliance, if they don't get reform and repair, then they move up gradually. But as soon as a company offers to comply, the regulator has to de-escalate. And so it's a combination of sticks and carrots, but the ideal is that the enforcer spends most of its time, most of its efforts at the bottom layer, the cooperative measures, because those are the most effective ways of achieving compliance. But you need the possibility of more severe sanctions to make sure that the lower layers work. In one sentence, that kind of sums up the idea: regulators need to speak softly but carry a big stick. And it's precisely because they carry a big stick that they can speak softly. And the bigger the stick, so the more scary the ultimate sanction, the less it will have to be used, and the more that the authority can focus on the bottom layer, on the more cooperative, consensual methods of enforcement. Now, responsive regulation is very influential, but does it make sense to apply it to competition law enforcement? The theory originated in Australia, and Australian scholars apply it to competition law enforcement without any hesitation, it seems. But I think there's some room for skepticism, I must admit, because the whole idea of the pyramid and escalating and de-escalating, it's premised on the idea that you have repeated interactions with the company that is being regulated, so that you can signal and the regulator can move up the pyramid or move down depending on how the regulated company behaves. Now, competition authorities, they oversee the entire economy, not just a sector. It's not like a financial regulator or a regulator for nursing homes. They oversee the entire economy. And so arguably, they don't have sufficient interactions. There's no repeated interaction with companies, arguably, because I think ultimately, yes, you can apply the theory, because, for instance, in Japan, the JFTC does have repeated interactions with many players. Why? Well, because it follows certain industries quite closely via sector surveys, but not just that. Very often, the same companies are investigated for various suspected infringements. Let me just jump you back, and apologies if you get seasick, to the to the slide on the cases against big tech, it's hard to say that there's no repeated interaction between the JFTC and Amazon, for instance, or Rakuten, or even Apple. So it's quite obvious that in certain sectors and with certain companies, there are repeated interactions. That's also true, I think, in other sectors, mobile network operators, convenience store chains. So I think ultimately it does make sense to apply the lessons of responsive regulation to competition law enforcement in Japan. Now, if we make this enforcement pyramid, for Japan, it would look something like this. And this enforcement pyramid of the different steps, the different possible strategies which JFTC can use, it's pretty close to ideal, I believe. I think many competition law enforcers would be very envious of the range of measures which the JFTC can take. It has a wide range of dialogue-based cooperative tools here at the bottom, and gradually the level of intrusiveness goes up. You have cautions, you have warnings, which are still informal. Then you have the voluntary measures and the commitments. And at the top, you have the more intrusive ones, not only cease and desist orders and administrative fines, but also the most severe sanction, criminal sanctions. So that really conforms to the rule that regulators should carry a big stick. And this big stick will precisely allow them to speak softly. So again, at first sight, you would think, wow, Japan is a great example of responsive regulation. They have developed a very good enforcement pyramid due to the genius of the Anti-Monopoly Act, which has not only administrative sanctions or administrative orders, but also criminal sanctions, and due to the creativity of the JFTC, which has been very good at developing these more consensual tools at the bottom of the pyramid. And I must say, there are also indeed examples of success. There are success stories which would seem to suggest further that, hey, this is responsive regulation. This is very effective. And I've listed two examples here. The first one is an example of how the surveys which the JFTC does lead to change. In 2020, the JFTC published a survey on convenience stores, and the report showed that the franchisors, so that's 7-Eleven, Lawson, Family Mart, the big nationwide convenience store chains, that they often made unreasonable demands towards the franchisees, so the shops themselves, which are often run by individuals. And the report indicated that this could violate the Anti-Monopoly Act, abusive superior bargaining position, other types of unfair trade practices. And the JFTC asked the chains to conduct an internal audit. So they had to inspect themselves and to take measures and then report back. And amazingly, all the chains did so. And these measures were made public. They were put on the website of the JFTC. You can consult them there, but they also received quite a lot of coverage in the press. And they seem to have led to some tangible change in the relationship between the large chains and the franchisees, the small shops. So that's an example of how the JFTC uses surveys to change business conduct, not just of an individual company, but of an entire sector, which seems a very effective way to obtain change. The second example is an example of a measure a bit higher up in the pyramid. It's not survey this time, but it's a commitment in the Amazon case. This was an investigation into Amazon's abusive superior bargaining position. The JFTC suspected Amazon of exploiting its suppliers And that investigation was ended after Amazon offered commitments. And the commitment was not just, okay, we'll stop exploiting, we'll stop doing this conduct of which you say that it's an abuse of superior bargaining position, but we'll also return the money that we took away from the suppliers. We'll return that to these suppliers, and these payments were made, and so the suppliers got some of their money back. So that's a commitment that didn't just say, okay, we'll stop the conduct, but there was also some restorative element in that commitment. And that's certainly something which responsive regulation and a related theory of restorative justice would encourage and would probably praise as a good example of how to solve things, not by escalation, but if the company offers a good repair, a good solution, then authorities should accept that and should use that. So those are all success stories, but there's also many examples that suggest the JFTC's consensual approach is not very effective. Okay, so the convenience store survey had some impact, but there's been a lot of surveys, and I must say I have a hard time identifying the impact of some of them. So I think some of them have had a very limited impact, and I think the JFTC also acknowledges that sometimes. For instance, the 2020 survey on startups highlighted a lot of problems. Small startup companies were being abused by investors, but a very recent survey in the same sector, 2021, found very little improvement. And so the surveys don't always work. And also a little higher up in the pyramid, the commitments, the voluntary measures. Well, I have strong doubts about the effectiveness of these measures in some cases. And the example I have in mind here is a very recent one. In 2021, Apple voluntarily, so it wasn't a commitment, it was a voluntary measure, promised to the JFTC to relax its anti-steering rules. And this was global news because Apple said, we'll do this, we'll implement this solution across the world, not just in Japan, we'll do it globally. And so the idea was that it would become easier for app developers to to offer a link to their customers. And if the customers click on that link, they go to a site outside of they go to the website of the app developer, and there they can make a payment to the app developer without having to use Apple Pay, and so without having to pay a commission to Apple. Now, Apple has implemented that voluntary measure, but at least in my view, it has implemented this in a way that still makes it very difficult for app developers to steer customers to payment methods other than Apple Pay. So I don't think Apple is implementing this in a very effective way. Now, why is it that this isn't effective, or why doesn't Apple comply with this voluntary measure in a more effective way? Well, in my view, it has to do with the fact that the Japanese approach to enforcement isn't entirely responsive regulation. It goes some way to responsive regulation, but it isn't quite there yet. And that brings me to the criticism on the JFTC's approach. The whole idea of responsive regulation is, of course, on the one hand, yes, it's good that all the focus is on the bottom layers, and that's where authorities should spend their resources and time on at cooperative methods. But that is, at the same time, I mean, responsive regulation is not just, oh, be soft. No, companies must perceive escalation, so tougher sanctions by the authority as almost inevitable if the cooperative approach doesn't work. And in the case of the JFTC, I think this may work well at the lower levels of the enforcement pyramid. So maybe let me first. So here, I think there is indeed the expectation of escalation. And so if the startups situation doesn't improve, yeah, now the JFTC does a new market survey, and probably they will become more aggressive, and they will start escalating their advocacy efforts, and maybe there will be some discussions with specific companies that are suspected of violating. Maybe there'll be some warnings. So I think at the lower side of the pyramid, this escalation works. But here, I think there's a problem. Here, there's no expectation, or there's not enough expectation by companies that the JFTC will escalate. So at higher levels of the pyramid, companies are unlikely to perceive escalation as inevitable. Why? Well, because the total absence of cease and desist orders and fines, for instance, in the digital market sector, surely that suggests to companies that the JFTC is reluctant to escalate. And as I mentioned, the JFTC is also constrained by political and institutional environment to be aggressive. It's not that easy for the JFTC to be aggressive. And if you then look at the top of the pyramid, the criminal sanction, yes, the Anti-Monopoly Act says that unreasonable restraints of trade, so horizontal anti-competitive agreements such as cartels, but also private monopolization is subject to criminal sanction. But I don't think any company or any lawyer really expects criminal prosecution for non-cartel cases. So the JFTC doesn't really carry a big stick in non-cartel cases. There's no expectation of escalation to higher levels. And so I think that's something that could be improved, and that would bring the JFTC's way of enforcing closer to responsive regulation. A second point of criticism is that responsive regulation says, okay, if a company offers to comply, then the authority should de-escalate and should take that and say, okay, great. But there's a flip side to that. Of course, once the company has offered to comply, for instance, by making a commitment, the compliance with that commitment must be strictly monitored, and in case of violation, there must be escalation. Now, the JFTC doesn't have that power. In the Japanese system, a violation of commitments, let alone a violation of voluntary measures, but even a violation of commitments doesn't carry a fine. A violation of commitments as such doesn't carry a fine. And so that's also, I think, a flaw in the architecture, in the enforcement architecture, which makes the JFTC's approach less effective. And then finally, and this one is perhaps more of a criticism of responsive regulation than anything else, but so responsive regulation says if the companies offer compliance, then the regulator should de-escalate. And I think that's fine and good in cases where the company can say, we will comply, we'll stop violating the law, and we'll repair. It must have a restorative element. And the Amazon case is a nice example where that is present. Amazon not only said, okay, we'll stop exploiting the suppliers, but we'll also pay back the money that we took from them in the past. And if you have that type of commitment, of course, you should de-escalate, and that's in line with responsive regulation. But in competition law, most commitments do not and cannot contain a restorative element. In the case of exclusionary abuses, it's much harder to envisage a restorative element. And so if there's no restorative element, if there's no repair, I wonder whether commitments, if offered, should always be accepted. I think it would make sense for an authority to then say, well, no, we escalate because you've learned from previous cases that this type of conduct is illegal, and so unless you can repair the situation, which often is not possible, we shouldn't de-escalate. So I guess that's a third point. Now, to conclude, I think the JFTC's focus on consensual enforcement merits attention and deserves praise. Surely there's much to learn here. The way the JFTC manages to enter into a dialogue with an entire industry and then uses that dialogue to advocate and obtain actual change, not just from a single actor, but from the entire industry, that is truly something that we should learn from. And other enforcers should try to emulate that, in my view. And likewise, I think there's also much to learn from the subtlety and the wide range of tools which the JFTC has developed to get voluntary compliance, consultations, warnings, cautions, all these strategies to get voluntary compliance. That all merits a lot of praise. But at the same time, I think the JFTC's enforcement style also has its flaws because it so rarely escalates, at least in the non-cartel context. Companies are unlikely to expect escalation, and that probably makes them less willing to propose effective measures on a voluntary basis, and that probably makes them less willing to comply fully with those voluntary measures. So the focus on voluntary and measures and on compliance and on cooperation is very good, but it would be even more effective if the expectation of escalation was more present. That's my conclusion. So yeah, some good things, some bad things. I'm very much looking forward to hearing what all the experts in the audience have to say about it. Thank you very much.